Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. On our docket today, we have the case of Cruz versus the state of Florida. Counsel?
Good morning. May it please the court and counsel. My name is Rafael Rodriguez. I represent Mr. Cruz on this direct appeal on a capital murder conviction and sentence of death. We have raised several issues on our brief, but I would like to take the opportunity during the course of this oral argument to address a few of them, time permitting. The first one I would like to address is the issues raised in issue 12 of our initial brief, dealing with errors in the trial court sentencing order. In particular, insofar as the disparity of sentence between Mr. Cruz and Mr. Charles, who's the co-defendant. As a way of factual background, Mr. Cruz went to trial first. He was convicted. He went to a penalty phase. The jury recommended or voted for death. And then the court handled a Spencer hearing, postponed the final sentencing hearing, heard the trial of Mr. Charles, the co-defendant. At that trial, the jury found Mr. Charles guilty on, according to the court, essentially the same facts and an identical verdicts. And the jury, however, voted for life imprisonment.
Let me ask you, can I interrupt you for a second? On Mr. Charles's case, were the charges against him identical to the charges against Mr. Cruz?
The charges were identical, and the court made that clear also as far as the verdicts at 3828 of the record, that the verdicts were identical, with the sole exception.
Well, I'm talking about the indictment. Was Mr. Charles also charged with first-degree premeditated murder as well as felony murder? That's
correct.
Okay.
The sole exception between the two defendants, as the trial court itself noted, was that the jury in Mr. Cruz's trial made a special finding that Mr. Cruz had possession or actually discharged a firearm causing the victim's death. Prior to Mr. Charles's trial, the state stipulated that Mr. Charles was not the shooter, and therefore the jury in Mr. Charles's case never had the opportunity to make that finding. As a result,
I'm sorry to interrupt you for one quick second. Am I reading the record right that the girlfriend of Charles who testified about the two different guns, did she only testify in Charles's case, or did she testify in Cruz's case also?
She only testified in Mr. Charles's case.
Okay.
Which dovetails with the other part of my argument that non-record evidence was utilized by the trial judge in his sentencing order, which this court has long condemned based on Gardner versus Florida. But as far as the firearm argument, we point out to the fact that the record in this case, there's no competent substantial evidence to support the special finding by the jury that Mr. Cruz was in fact the shooter. We raised that in issue 5 of our brief. In particular, the lead detective was asked on direct examination by the prosecutor, do you have any information as you sit here right now to know which of the two individuals alleged actually fired any shots in this case? And his answer was, no, sir, I do not. That is the evidence below and prior to the guilt verdict rendered by the jury. And so our position is that if an entire conviction can be vacated as a result of lack of competent substantial evidence, certainly a special jury verdict finding can. And in this case, that's exactly what we're asking this court to do.
What about the argument that your client was charged in the indictment with premeditated first-degree murder and that the jury found him guilty of that? Isn't that factual finding by a jury sufficient?
Sufficient for
a firearm?
Well, no, because they were then specifically asked whether he was in possession or discharged a firearm. Mr. Charles was convicted of the same thing. and yet he was sentenced to life. So my point being that if that's the case, the trial court itself in its sentencing order found that the defendants were equally culpable. That was a finding of the trial court at page 3822 of the sentencing order. And so when you have defendants who are equally culpable, this court has time and time again ruled that they cannot be sentenced disparately. And that's exactly what occurred in this case.
It seems like your better argument would be that the trial court, the entire order is sort of permeated with the distinction of your client having been the shooter and whether there was evidence to support that. I mean, the judge didn't think that they were equally culpable. He obviously thought that your client was the shooter and that was a meaningful enough difference to justify the death sentence. That's the way I read the order.
Yes, Judge, that's exactly what the judge, he didn't have any analysis of the facts which are now being put forward by the state as to the relative culpability of the two defendants. All he said was the jury made this finding and that's good enough for me, basically, in order to impose the death penalty. But he actually referred to the testimony of the girlfriend, which is part of that issue 12, indicating that Mr. Cruz had possession of a .22 caliber firearm and that they had formulated a plan to rob Mr. Walters. Well, that wasn't part of Mr. Cruz's trial at all. That was exclusively in Mr. Charles's trial. And yet the trial judge incorporated those findings in his sentencing order. And this court has always said that you need to review the entire sentencing order in its entirety to make that determination and not segregate sections. Well, he made that finding in the factual portion. He made that finding as far as the avoid arrest aggravator, indicating that that aggravator was lent validity by the fact that Mr. Cruz brandished the firearm according to the girlfriend's testimony. So we believe that this order is unsupportable by competent substantial evidence, in particular as to disparity of sentence. I would point out further that the prosecutor below never, ever informed the jury that they believed that Mr. Cruz was the shooter. They always couched their arguments as they committed this offense. They bound and gagged the victim. They committed this burglary. They drove him to a secluded location. They shot him. In fact, the prosecutor indicated very amorphously that one of them stood over the victim and shot him. Someone stood over the victim and shot him. Somebody stood over him and shot him. Those are all in the closing arguments that the state presented to the jury.
So your basic argument then is that because we don't know who the shooter was, as far as the evidence is concerned, then both defendants should receive the same sentence.
That's correct. Once Mr. Charles received a life sentence, since they're equally culpable, according to the judge, but for that special finding, then they should be treated alike. And so
I'm just wondering, what if the jury had recommended death for Mr. Charles and he had been sentenced to death? What would your argument be here today?
The argument would
still must have been the shooter?
Well, no, that the argument would be that there was not competent substantial evidence to support the jury finding in Mr. Cruz's trial, irrespective of what occurred in Mr. Charles's trial. Because once Mr. Charles was sentenced, then this issue became ripe. Then this issue became something that I could raise as a disparity of sentence. Prior to that, the matter wasn't ripe. It couldn't be raised because we don't know what would have happened in Mr. Charles's case. But once Mr. Charles received the life sentence, then the issue of disparity became ripe for this court's determination. And an issue of comparative culpability.
I mean, it's a little complicated here because if you're looking at it from looking back on it to evaluate that issue from the perspective of what happened in the Charles case, that shows that there's evidence there that would support the conclusion, and that there's stipulation by the state also that would support the conclusion that Mr. Charles was not the shooter. So that's one aspect of this, but it seems to me, I kind of echo what Justice Mooney says, is that your focus on the fact that the trial court here, in its decision to impose the death penalty, relies on this jury finding that that Mr. Cruz was the shooter, or that he did shoot. Okay, I don't guess it's exclusively him, but it says that there's that finding that he discharged a firearm and resulting in the death of the victim. But there's no evidence in Mr. Cruz's case that actually supports that.
That's my
And so
argument.
the trial court has relied on a factual finding by the jury, and it seems to be kind of it seems to be central to the analysis of the trial court. The reliance on that finding, which, you know, we can search the record here, and there's no support for it. And that's kind of I mean, you've got a variety of arguments, but isn't that kind of the heart of your argument?
That is the heart of your argument, Your Honor. I'm glad you put it in such pithy terms, but that is in fact exactly what we're suggesting to the court, that the record, if the court reviews this record from back to front, it will not find competent substantial evidence to indicate that Mr. Cruz was the shooter. None of the arguments advanced by the state on appeal now were advanced by the state below, nor cited by the court in its order. The court simply and exclusively relied on the fact that the jury found that he had been the shooter.
Well, he also seems to have relied on the girlfriend's testimony from the other case.
That is correct, and that is improper because this court has said that over and over again. That evidence was never, the defense lawyer was never given notice that the court was going to rely on that information. That information was never independently developed at the defendant's trial. So all the exceptions that this court has noted over the years that perhaps we can overlook the fact that a court has relied on non-record evidence do not apply in this case. The court specifically referred to this information from the girlfriend's damaging testimony from the girlfriend's testimony that Mr. Cruz possessed and brandished a .22 caliber pistol, which was not brought out in Mr. Cruz's trial. So we believe that under the
other aspect of that was that Mr. Charles had a weapon of another caliber. Isn't that correct?
That's correct, 9mm.
So, and there is evidence in this case that supports the conclusion that the victim was killed by not by 9mm, but by
that is correct. In fact, a .22 caliber spent cartridge was found at the scene where the victim was shot. So that even made it worse because now the judge is relying on information he received in a separate trial for which Mr. Cruz's lawyer was not present in order to substantiate his feeling that the jury had made an adequate ruling, because there was a motion for judgment of acquittal on this point filed by the defense, and it was denied by the trial court. So the issue is ripe for this court's determination. This was not something that we're bringing forward to the Supreme Court now, that had not been brought before the trial judge himself at that time. And one last point on the reliance on non-record evidence, the trial court seemed to have recognized that it was improper for him to do that because he actually referred to jailhouse testimony in Mr. Charles's trial and said, well, I'm rejecting because I don't find it was credible and because defense lawyer did not have notice or was not present when that testimony was presented. It wasn't as if the trial judge was ignorant of this court's prescription that he cannot use non-record evidence. He was aware of it, and yet he still relied on it. So based on those two aspects of that particular order, we're asking this court to vacate the sentence of death and remand for the imposition of a life sentence. I would like the court to—
Well, let me ask you this, why is that the correct remedy?
Because this court has previously said so.
Well, let me expand on my question and then give you a chance to answer. Why wouldn't the correct remedy be to remand it to the trial court for a reevaluation based on the record evidence before him, and without consideration of non-record evidence?
Well, I mean, that's always an option for this court to do, but I think the record is abundantly clear. It's not going to change. I mean, the government is now arguing, well, the jury could have found a difference in their roles, irrespective of the firearm. But once again, those are not facts relied on by the state below, nor were cited by the court in its order.
Well, again, just the way these cases are presented, if you're looking back on it in terms of the relative culpability, the way the cases are presented and the way the state tries them does make a difference. So if the state stipulates that Mr. Charles was not the shooter, then that just puts that case in a little different category, doesn't it?
Well, it virtually guaranteed a disparate sentence. Virtually guaranteed it, because at that point,
but again, there was an evidentiary basis. At that point, the state had a very good evidentiary basis for that stipulation and for that distinction, didn't they?
They may very well have, but in Mr. Cruz's trial, the court didn't make any type of analysis. It simply relied on the jury.
I understand. I'm kind of beyond that. I'm thinking that we're thinking about what if we should decide to reverse this, what the remedy would be and how that would potentially what the factors would be in determining that. But right. I appreciate.
Thank you very much, Your Honor.
Mr. Rodriguez, I also have a question or a series.
Yes.
To me, this case seems analogous to the case where you have co-defendants, one of whom is a juvenile, so that the death penalty is simply not available. Here you have a co-defendant. I mean, we don't have jury sentencing in Florida. We have the judge is a senator. But once a separate jury looks at a case, including different mitigators, it's not just that the facts that might be aggravating would be different in one trial than the other, but the mitigation is going to be different, and you have a different jury, and some individuals may just view things differently. So, but the bottom line is that the death penalty was not available for Mr. Charles. So in that context, why would we even do any comparison? Why shouldn't it be treated as if Mr. Charles was a juvenile? I mean, any reason why the death sentence was not available to the senator for one co-defendant and not the other? Does that make sense?
I understand. I think I understand what Your Honor is saying, but I think that the argument still boils down to whether or not, irrespective of Mr. Charles's trial, whether there was competent substantial evidence to support the jury's special finding. If there wasn't, then he's in the same boat as Mr. Charles, because he was convicted of the same offenses, and the jury found the same aggravated.
But I mean, I get the first part of your argument, but when you tie it to anything related to Mr. Charles, that's where you lose me, because there were a lot of differences in the trials. I mean, that was one.
Well, true. And if we look at Mr. Cruz's trial, which let's focus on that. If anything, Mr. Charles was more culpable. He the one who brought up the issue of going to Mr. Walters' apartment. It was his footprint on the door that knocked the door open into the apartment. It was his blood that was on the hallway and in the entranceway into the apartment. It was he who drove the victim to the secluded location, and it was his shoe print on the victim's shirt, indicating that he may have stomped on the victim. So
I guess what I'm suggesting and asking you to tell me why this is not correct. If the death penalty is not available to one of the co-defendants, why would we look at relative culpability?
Okay, and I would,
and the other context in which we don't look at relative culpability are when one of the co-defendants is a juvenile, so the death penalty is not available, or when one of the co-defendants pleads to a lesser offense. I mean, that's my recollection of the law. So
That's
why is
correct. But in the case of the 16-year-old, there's a constitutional prohibition. In this case, it's a simple factual comparison between the two cases. I mean, simply because the state may enter the stipulation, it deprived the jury of the ability to enter a special finding. They could have found a special finding if given an opportunity in Mr. Charles's case, but they didn't do that. In
Well,
this,
counsel, let me ask this. It is the case that someone can be guilty of premeditated first-degree murder and can get a death sentence even if they're not the shooter.
that's correct. I mean, there are cases that say that, but in this particular case, we're dealing with a situation that the judge based it exclusively on that point, based on his order. I can't go beyond the four corners of his order.
I mean, the bottom line is the culpability, the relative culpability in the comparison is really a red herring from, I would think, from your perspective, which is the order is based on either a jury finding that wasn't supported by evidence in the record or by the girlfriend's testimony, which was from another case. I mean, forget about the relative stuff. I mean, the point is this particular death sentence appears to have been justified by the sentencer, i.e. the judge, based on facts that might not have been supported by the record that he was properly able to consider. I mean, isn't that the bottom line?
That's the bottom line, Your Honor, but I wanted to bring out the issue of the co-defendant sentence only to bring to the fore the reason why we feel that Mr. Cruz in particular sentence should be vacated because of the lack of evidence to support a jury finding in his case that he was the shooter. So if he's equally culpable as the judge himself found in his sentencing order, then he's equally culpable. At that point, it becomes relevant as to what he did with Mr. Charles, because he said they were equally culpable. If you knock out the firearm finding, because there was no competent substantial evidence, they stand on the same level. They stand on the same level. And this court has particularly said that people who are in the same situation should be treated the same. And that's why it was brought up to the court's attention. Now, I would like to address before my time expires, the only other issue I think I have time for is the numerous improper closing arguments made during the penalty phase. I recognize up front that trial counsel failed to object to any of these, but they were made in the course of 23 pages in a very truncated fashion and covered a lot of territory that was improper. This prosecutor, Mr. Will, made statements that were outrageous to begin with, and there was no attempt to object to them, and the court did not intervene saying, hey, stop. In this case, Mr. Will went on to say, compared him to his sister living in the same house. This is not a general comparison to the general population. This is denigrating his mitigation. And then he said, Mr. Cruz torched his mother in public. Unfortunately, the trial judge picked up on this when he said that the mother was vilified. Okay, so these are non-statutory aggravators when Mr. Cruz is simply trying to say why he grew up the way he grew up. The prosecutor also argued to the jury that they should disregard the fact that he had committed suicide, that they should disregard his ADHD and bipolar disorders, which were established on the record without dispute. And then he actually told the jury that he knew the difference between right and wrong. This court has said that that's not the standard when you're assessing the two statutory mitigators of extreme emotional disturbance and appreciation of criminality. Those are cases cited in our prior brief indicating that it's not the standard. But the worst arguments that this prosecutor went on to say was, it's the kind of crime that frightens you to your core. It's the reason that children fear the darkness. It's why people have locks on their doors and keep guns for protections. If this is not an improper comment, I am very stretched to find out what it is. Introducing the concept of social crime and crime in the streets interjecting into this proceeding. He then created a script that was made out of whole cloth as to what the victim was hearing about a supposed conversation when we don't even know he was conscious when he was in the trunk, indicating that they talked about it, and Mr. Jeremy had to listen to it, and he knew what he was going to add. This is all made up. There was no
Counsel, you can keep going, but I just want you to be aware that you are now into your rebuttal time, and you've used about a minute of it.
Okay, well then in that case, I would ask that the court reverse and remand this case. Thank you.
All right, thank you. Counsel for the state.
Good morning, and may it please the court. My name is Patrick Bobeck, and I represent the state in this case. I'd like to start by addressing this special jury finding that Mr. Cruz was the shooter. I think it's only relevant to one issue, and the issue is relative culpability. And I'd like to point out to the court that recently in Lawrence v. State, you receded from comparative culpability or comparative proportionality and said that it didn't comport with the Florida Constitution's conformity clause with federal Eighth Amendment jurisprudence.
Well, do we really need to go there? I mean, I think what the argument has been is that there is no competent substantial evidence to show that Mr. Cruz was the shooter in this case. And the only thing you have to show for it basically is that the state stipulated that Charles was not the shooter. Somebody shot this guy, therefore it must be Cruz. That seems to be it.
Right. By stippling relative culpability and its reliance here should be addressed. When the court receded from comparative proportionality in Lawrence, it de facto proceeded also from the relative culpability analysis.
But we're not going there. I mean, we're just saying you haven't proved it.
Okay. So I think even if this court were to throw out the jury finding, you still don't have equally culpable defendants because that would leave the Cruz with, we don't know if he was a shooter, and it would leave Charles with, he definitely was not the shooter. That still makes Charles more culpable. And so we'd still meet that relative culpability analysis if the court wanted to make it. But I don't think the court any longer needs to do a relative culpability analysis.
You mean Cruz, not Charles, would be more culpable in that?
Yes, I'm sorry, I misspoke.
Okay. So can we just, let's just focus on the record for a second. Is the caliber of the firearm recovered from Cruz in the record at Cruz's trial?
No.
If that's not in the record, direct us to what record evidence there is to support the jury's finding. And if there is no record evidence, tell us so.
So I think there is record evidence the jury could have relied on to find that he was the shooter. The two most compelling pieces of evidence I found were that there was a concentration of pistol whip markings on Mr. Jemery's face, on the right side of his face. And Mr. Cruz is left-handed, so that shows he was wielding a gun that night, and that he was the passenger in the car, and Mr. Charles was the driver of the car the entire time. And we have Mr. Cruz on camera at an ATM getting out of the car while Mr. Charles waits. So I think I think those kinds of things are what the jury might have looked at.
Okay, first, about where the pistol whipping was administered, how could you infer anything from that? I mean, because you don't know whether he's standing looking down over him or he's above his head looking. You just don't know what direction he's approaching him from as he's pistol whipping him, do you? I mean, is there any evidence about that?
There's not, Judge.
That just seems so entirely speculative.
I'll be the first to admit that the state didn't put on nearly as much evidence as they could have for this finding. And so if this court is going to reject that finding, I still think that it doesn't have any bearing on the outcome of this case.
But counsel, can you elaborate on that? Because do you agree or disagree that if you read the order and you try to understand the court's own kind of justification for why it was imposing the death sentence, the way I read the order is that who is the shooter was a very significant, if not the sort of determining factor as to imposing the death sentence. Obviously, there's the court was very highly influenced by the videotape of, the other incident and everything. But it seemed to me that if you take out the who's the shooter part of it, you really couldn't have any confidence that the sentence would have been the same. But could you respond to that?
Sure. And the way I read how he finally concluded his order as to that, he said that the only reason he thinks Charles escaped the death penalty is because it was stipulated that he was not the shooter. And I think that's very convincing mitigation that he would have been able to rely on in his trial that led to this different result. I didn't read it as I'm sentencing Cruz to death because he's the shooter. I'm just recognizing that Charles escaped the death penalty because the state stipulated he was not the shooter. And so the mitigation aggravation was different for the two cases because of that.
And you agree and recognize that the trial court did say that they were equally culpable, Charles and Cruz, correct?
Well, I think, yes, he did. He said throughout that they acted in concert.
They were equally culpable. I mean, doesn't that logically lead to the conclusion that he would have imposed the same penalty on Charles if, I mean, mitigation's different, but in terms of whether he was a shooter or not, if they were equally culpable, it seems like that cuts in your favor, but I'm not sure exactly how.
Well, again, I don't think the conclusion is that they are equally culpable because Charles had the benefit of, I am definitely not the shooter to rely on.
The trial court's statement about equal culpability is a little odd. It says both were equally, and I'm quoting it here, both were equally culpable for the actions of each other. Now, that's not exactly like saying that they were equally culpable for the crime. I've just never seen anything quite like that. Do you have any comment on that?
I don't, Judge.
I don't know whether that helps or hurts you. But I point out that is what the trial court said.
And counsel, what's your position on whether it was okay for the court to have considered the girlfriend's testimony from the other case as far as who had which gun?
So this court's precedent is pretty clear that the trial court is not supposed to rely on non-record evidence, and I don't think he did here. He did mention it in his recitation of the facts, but he did not rely on her testimony in finding any of the aggravating factors.
Well, but I mean, wasn't that, I mean, really wouldn't, if that same evidence had been in this trial, we wouldn't be sitting here speculating about whether there was evidence to support who the shooter was. I mean, it seems like that's the most direct way to get to the inference of who had the 22 and therefore who shot who was the shooter of the fatal shot.
Right, but I don't think he relied on her testimony in finding any aggravating factors. Again, who is the shooter is not an aggravating factor.
Right, but that's just, the aggravator is only, that gets you, obviously, the eligibility question, but as far as the selection and weighing and understanding the, all the facts and circumstances of the offense and everything, all the other variables that go into the actual sentence, it seems like that was a significant part of it.
And again, I would just point out that in analyzing who the shooter is, I think the judge was pointing out that the benefit Charles got, the mitigation he would have been able to present that I definitely did not shoot him, the other guy did, was a significant factor in his case. And I think that puts it in a different light than I am relying on the fact he's the shooter and sentencing him to death. That's how I read that part of his order.
Well, counsel, I understand what you're saying, but this idea of Mr. Cruz being the shooter and that having been established by the jury seems to just kind of pervade this order. And obviously that's significant. That is not an insignificant factor in weighing everything and determining what the appropriate punishment is. So I'm just struggling to see how we could say that error was harmless beyond a reasonable doubt. Help me if you got anything else to say on that. But I think that might be the question. It's admittedly it's an error to rely on it. It seems to me. since it's unsupported by, I mean, you've made an attempt to come up with some support for it, but it's pretty feeble.
Right. And again, I would say that the facts of whether Cruz is the shooter is only relevant to a relative culpability analysis, and that is no longer in comporting with the Florida Constitution. I think that's its only relevance in this case. He doesn't mention it throughout the order, but he doesn't.
I'm not sure I agree with that statement a lot. We've been through this before. I don't know that you need to go there, but you read the Lawrence opinion as doing with relative culpability as opposed to the proportionality of how the death penalty is administered. That's the state's position on that case.
So McLeod v. State in 2016, Justice Kennedy pointed out that relative culpability is an aspect of your comparative proportionality review. So if you get rid of comparative proportionality, you have de facto gotten rid of relative culpability.
I'm not sure I follow that getting rid of something means getting rid of an aspect of it, but
well, if it's part of the analysis and that analysis is now gone.
It is true that it's part of that analysis, but it's also, for example, a part of general sentencing principles to consider relative culpability. It's part of conspiracy law. It's an aspect of all those other things. And you wouldn't say that those things have been eliminated by our decision on proportionality, would you?
No, I would say specifically in the death penalty context, the floor is Inman Tyson. It's that somebody who is less culpable cannot be given a greater sentence. Equally culpable defendants federally can be given different sentences. And so in the context of the death penalty case law, it wouldn't apply anymore.
But I mean, I think the argument here isn't that it's unconstitutional in terms of a relative comparison, which is what the Lawrence stuff gets to, is that if a judge's discretionary decision is motivated significantly by a fact that is not proven, or that was proven with evidence that wasn't allowed to be considered, then doesn't that sort of undercut the validity of the order of the decision? I mean, that's the question.
Right, and I would just rely on my previous argument that I don't think he was talking about it in deciding factor of Cruz's case, but that Charles got the benefit of mitigation in his case. That's how I read his order. So I don't think it was the deciding factor. I think the 5 aggravating factors that he gave great weight to were the deciding factors in this case. So then I'd like to move on to the prosecutor's closing arguments in the the penalty phase. The first thing I'd point out to the court is none of these were objected to, so they'd have to rise to fundamental error, meaning the recommendation of death could not have been reached but for these comments. And this was a greatly aggravated case. Like I said, there were 5 aggravating factors: HAC, CCP, avoid arrest, in the course of a felony, which was 3 felonies, and a prior violent felony, which was a robbery he committed only 1 week after this occurred. In relation to that, he had 37 mitigating factors that were found, and 2/3 of them were only given slight weight. So this was a greatly aggravated case with mitigation that just didn't stack up. In that context, these comments, those which the court might find objectionable, do not rise to the level of fundamental error in the idea that we would not have reached this 12-0 recommendation. And specifically, some of them I don't think are objectionable at all. For example, when he refers to the defendant's sister and how she turned out all right, I think that's a fair comment on what weight the jury should give the mitigation. We have someone here who lived through the same things he did. And in fact, she testified that she had it harder because she had to be supportive and strong for him when he was upset, and she couldn't feel the emotions she wanted to feel because she was the older sibling. So being able to point to a counterexample and say, look, she's okay, is a really good way to say this mitigation is just not that weighty. But I would mostly rely on my fundamental error argument there. If there are no further questions, I would just ask that the court maintain this convictions and sentence.
Could you
I do
address
have one
the
further
remedy
question.
question? I'm sorry. Go ahead.
And that is, what would be the correct remedy, do you think, if we determined that the trial judge relied on matters that should not have been relied upon in the sentencing order, and we can't tell whether that reliance would have made a difference in the ultimate sentence. What would be the right remedy?
If you can't tell whether it would make a difference, I think that would show that the error was harmless beyond a reasonable doubt because it didn't rise to.
No, I mean, what I mean is, if the trial judge had not relied on the girlfriend's testimony, Charles' girlfriend's testimony, and had not relied on the finding that wasn't supported, assuming that we determined that that's true, we can't tell whether that would have influenced the ultimate sentence or not. Whether if you remove those things, would the sentence have been different? So if we can't tell one way or the other, it might have been different. Then what would be the remedy?
Well, again, it would have to. I think it would have to rise to fundamental error that it could not, the sentence could not have been reached but for the errors.
No, I think the question that Justice Lawson's getting at is, does the court get an opportunity to essentially remake the decision without those evidentiary issues, or is the remedy to say that essentially send it back for imposition of a life sentence?
Yeah, so if this court were to reverse, I think the proper remedy would be to remand for a new sentencing hearing. That's what the court has done in the past when it's thrown out some aggravators or found some mitigators to be more weighty than the trial court gave it, to have the trial court do that weighing process. So I think you would be able to remand it to the trial court to reweigh everything without those findings.
So not a new hearing in the sense that the state gets another bite at the apple of presenting evidence on who is the shooter, but essentially, freeze the evidence that's properly considered and then have the court sort of redo its calculus and then impose whatever sentence it thinks is appropriate.
Yes. There are no further questions? Thank you for your time. Yep.
Thank you, counsel. We will now hear a rebuttal.
Very quickly, I disagree with the state's interpretation of the order. I think Justice Kennedy stated correctly that it sort of pervades the order. That is, the finding that he was the shooter. It made the order from one point to the other on that point. In fact, in the Edmund Tyson section of the order, the court basically said the jury made that determination. No further analysis is needed. And that's on page 3800 of the record. And further, he did use the non-record evidence in the avoid arrest aggravator, specifically referring to the girlfriend's testimony. So for the state to suggest that that did not actually occur in the order is incorrect. He did make reference to it. I also take objection to the state's interpretation of Lawrence as saying that it wiped away the disparity jurisprudence of the Supreme Court. It did no such thing. It dealt exclusively with proportionality. And there was no language in Lawrence addressing that point, and the state didn't brief that point before this court, before announcing that that was the position that the state was taking. So we would ask the court to reject that argument outright. And we would also point out that insofar as the sister's testimony and the closing argument, the prosecutor said she turned out fine. Well, actually, the sister testified at the penalty phase, and she said that she was under evaluation and medication because of the way they were raised. So it was misleading the jury and telling them that she turned out fine when there was record evidence to the contrary. So we would ask this court to take that into consideration, and then we would ask that the court reverse the penalty phase and remand to the trial court without giving up our arguments on the guilt phase, but that's another issue.
All right, we thank you both for your arguments in this case today. And that concludes today's session of court.